On the 19th of March 2024, Justice Nixon Sifuna, sitting at the High Court in Murang'a, declared life imprisonment unconstitutional. In his judgment, the judge argued that a life sentence is impossible to calculate and violates the right to human dignity guaranteed under Article 28 of the Constitution. Justice Sifuna set aside a life sentence handed by the Magistrates' Court in Kigumo and gave the appellant, who had been convicted of incest against his 10-year-old daughter, a prison term of 10 years instead. The judgment has triggered mixed views within the legal profession.
When you read Article 165 of the Constitution, it presupposes that the High Court has the power of making a determination whether anything done or said to be done has been done according to the law. So it has the original jurisdiction. And I want to make this comparison using what happened during the Muruatetu decision. Remember the Francis Muruatetu decision where the Supreme Court decided that the mandatory nature of the death sentence is unconstitutional. The Supreme Court then had been invited to also make a determination on the question of life imprisonment. But what did the Supreme Court do? The Supreme Court decided to remand that issue. Decided to ignore the determination of that issue, since that issue must first flow from the High Court. So the High Court, it grows to the Court of Appeal, it grows to the Supreme Court. So as we speak now, the determination made by the Court of Appeal has since now been overtaken by events, because a determination as to the constitutionality of the life imprisonment has been made. So as we speak now, that sentence, the life imprisonment, has been declared to be unconstitutional.
Justice Sifuna got it wrong, because the Court of Appeal in the case of Julius Kitsao Manyeso versus Republic, the Court of Appeal sitting in Malindi, Justice Odunga, Justice Nyamwea, and Justice, what's her name? I forget the name, but the three-judge bench of the Court of Appeal had made a decision. And in this decision, the court had stated that Section 8 of Section 8.2 of the Sexual Offences Act was unconstitutional for the reason that it made it mandatory as a sentence anyone convicted of defilement. So if the Court of Appeal had expressed itself on that matter and said it was discriminatory vis-a-vis Article 27 of the Constitution, it was not open for Justice Sifuna again in the case of Justice Ndongo, which he rendered last week, to again purport to declare that provision unconstitutional, because once the Superior Court under Article 164 had declared that that provision was unconstitutional, that decision bound all the courts down the hierarchy.
The Court of Appeal confronted the same question in July 2023 and ruled that mandatory and indefinite life imprisonment violates the Constitution, as it denies a convict the right to offer facts that mitigate their sentence and restricts the discretion of the bench. Uncertainty now remains on the way forward.
We had the Supreme Court in the Muruatetu case when it dealt with the mandatory nature of the death sentence. The crisis in the criminal justice system was unparalleled. People don't know what to do. Let's see what the Supreme Court will do. I wish the Attorney General would have acted as was advised in Muruatetu 1, whereby they were asked to prepare law to govern the sentencing. That needs to happen so that the criminal justice system is not in crisis.
The judgment that was delivered by Justice Sifuna, seated in Murang'a High Court, is not binding on other judges, because they enjoy the same powers and privileges. They have what is called concurrent jurisdiction. Individuals who are currently serving that sentence, people who've been commuted to now life imprisonment, have an opportunity in law to now approach the courts again and say, please review my sentence.
Muriel Adhiambo, K24 TV, Nairobi.